They registered a character trademark for shaver Shebang, which is a class 3 cleaner for use on electric shavers. We will soon be launching a new version that we want to call shaver Shebang Supra. There's an active character mark for Supra, which is class 3 for liquid soap. Would the addition of the word Supra infringe? So a very specific question here.
It's a very pointed question, and this question calls out, class 003 is often the way that it's listed, 3 numbers, but a cleaner for electric shavers, liquid soap, just for cleaning things like soap cleaners and stuff like that. These categories tend to be fairly broad, and I'll point out, tend to be non-obvious at times, right? So you kind of need to go and look it up, and there are places, and we can provide links or whatever later, that says, here's what's in this class 003. Oh, okay. And here's specifically what's not in the class to try and help define what the class is, right? Because you can't just give it a title and go, oh, well, I know what goes in there, it's soap. Well, right. No, it's cleaners, right? Anyway, so you've listed the one class. You've already got a name. I'll just say it's a registered trademark that you have. Go ahead and state that. You're thinking about adding another one, and you're going to add this, right? Kind of like adding another beer. If I'm a brewery, I've got the name of my brewery, and I've got a lager, but I'm going to do an IPA, and it might even be an additive title or something like that. So these are all trademarks. As soon as you've got the second beer, you've got 3 trademarks. So you're in the right spot, and you're asking the right questions. It's a very interesting question, because you're saying, I've already got this name, but this other component of the name I'm considering also already exists in the same class for something slightly different. Here's essentially the answer. The trademarks need to be considered in their entirety, right? And you look at a trademark and you've got some words, or it might be a logo or what have you, but the analysis isn't exactly on those words. It's on something called the commercial impression. So, well, what the hell is a commercial impression, David? You're confusing me even more. Well, think about it this way. Think about a bottle of wine called Elephant and another bottle of wine with a picture of an elephant on it. The word and the picture are vastly different things, right? If we hold them together, you go, well, that's this one and this one, they're not the same. Those are clearly different manufacturers of wine, whatever. But that's not how they do the analysis. It's not side by side. It's like I'm looking at this word, and then we're assuming that I tell JD this was great, and he goes to the store and he buys a bottle of wine with an elephant on it, and it's garbage, and then we never talk again, right? So you have to take the whole thing into consideration. So in this case, the first 2 words and then adding Supra. The concern is there's another registration for Supra. The question then is going to be, are they different enough? The whole thing is based on confusion. Would a consumer be confused if both of those marks were used in related goods, sufficiently related goods? So then, even though those marks must be considered in their entirety, they can have a primary component. I'll just call it a primary component to that mark, right? So if you add an S and make a mark plural, the primary piece of it is the same, even though they're different marks.
Yep.
Patent versus patents. Those are different, objectively different, but it's kind of a subjective analysis. So they look at, well, what's the primary part? The primary part is patent. And so you end up being denied. So in this case, those words come before Supra. Supra is just says, hey, it means like better or first or that kind of thing. It's suggesting that. I would call the primary component shaver Shebang, not Supra. You might run into trouble if Supra is like super famous, like right. Gucci. If you said, Shebang Gucci, they might go, oh, well, kind of Gucci's the primary piece in the mark you're suggesting, and so it's not going to work. I don't think that's the case here. I would look into it more. Of course, if I was going to actually give you legal advice, which we aren't doing, I would do a little bit more of a deep dive. But just based on what we have in the question and how trademark law works, you're looking at your primary component. You can't really mess up a mark by adding some smaller component that's already registered. So
Okay.
it's a complicated thing. It
Yes,
really is.
totally.
But
No, I think so. It sounds like the answer is
I'm not terribly worried.
not terribly worried. You should hire counsel to dig into it. It was a great thing for them to sort of stop and ask.